Good morning. This is your Kelso Report for Monday, March 19th, and I'm your host, Clark Kelso. We have cases today dealing with arbitration, ERISA, habeas corpus, veterinary malpractice, civil procedure, and banking law. We get started with a Ninth Circuit case involving arbitration. The battle over the enforceability of certain types of arbitration provisions in consumer contracts continued in Conniff versus AT&T, where the Ninth Circuit held that the district court erred in concluding that a class action waiver provision in AT&T's wireless services contract was substantively unconscionable and therefore unenforceable. In reaching this conclusion, the Ninth Circuit bowed to the Supreme Court's decision in AT&T Mobility versus Concepcion just last year, where the court had reversed the Ninth Circuit's holding that the Federal Arbitration Act did not preempt California case law, providing that class action waivers in consumer contracts were unconscionable as a matter of law. The Supreme Court made it clear in Concepcion that the Federal Arbitration Act's preemptive reach is broad and deep, and that a special California rule designed to strike certain arbitration provisions in consumer contracts was contrary to the FAA's broad policy favoring arbitration. Now, interestingly, in Friday's decision, the Ninth Circuit remanded for further proceedings regarding the plaintiff's claims of procedural unconscionability. The case came to the Ninth Circuit from a Washington district court, and the law of Washington apparently may permit a contract or contract provision to be struck down solely on procedural unconscionability grounds, even absent a finding of substantive unconscionability. Well, we'll see if that really is the law of Washington. That would be an unusual version of the law of unconscionability. In any event, although the plaintiffs have lost on the substantive unconscionability argument, they still apparently have a shot at striking the arbitration clause on procedural unconscionability grounds. Now, to me, this sounds a little like an attempt to do an end run around the Supreme Court's decision in Concepcion, but we'll have to wait to see what the district court makes of the procedural unconscionability argument, and if it strikes something down, what the Ninth Circuit does in response. Our next case arises under ERISA, which is always a very complex and technical area of law. This time, the plaintiffs in Skinner versus Northrop Grumman Retirement were nearing retirement, and they had received retirement packages that described in general terms what benefits they should expect to receive. The packets arguably contained information that was ambiguous and possibly inconsistent with the actual plan with respect to something called an annuity equivalent offset that plan administrators use to reduce annual benefit amounts based on the age of the participant at retirement. The plaintiff's primary argument was that the summary plan descriptions in the retirement packages actually modified the plan documents so that the plaintiffs could enforce the language in the summary plan descriptions. Well, unfortunately for the plaintiffs, the Supreme Court decided last year in Cigna versus Amari that summary documents do not themselves constitute the terms of the plan. So the plaintiff's primary argument in the case before the Ninth Circuit was clearly precluded. This left plaintiffs to argue that the allegedly ambiguous and inaccurate statements in the summary plan descriptions justified some other type of equitable relief under ERISA. In particular, plaintiffs argued for reformation of the plan documents. But the Ninth Circuit rejected this request because there was no evidence of fraud or mutual mistake, which are the only general bases for triggering reformation of a contract or trust instrument. Next, we have a habeas corpus case. In Phillips versus Ornosky, a split panel of the Ninth Circuit granted that portion of a habeas petition challenging imposition of the death penalty. This particular petition was filed prior to the effective date of the Anti-Terrorism and Effective Death Penalty Act, so pre-act standards of judicial review applied. The prosecutor in the case concealed from the defendant and misled the jury regarding evidence that was pertinent to the special circumstances finding that the murder of which the defendant was charged was committed during a robbery. In particular, one of the prosecution's witnesses received special treatment from the government in return for her testimony. Yet the prosecutor denied that there was any special treatment given to the witness. The witness's testimony was a strong basis for the jury's special circumstance finding that the murder was committed during a robbery, instead of the alternative factual theory that the robbery was committed as an afterthought after the murder, which under California law is not a ground for a special circumstance finding. Given that the prosecutor had violated due process by his concealment and misleading statements to the jury, and the evidence concealed was material to the defense and required for imposition of the death penalty, the Ninth Circuit struck the death penalty from the judgment. And otherwise, the Ninth Circuit rejected the petitioner's other habeas claims. Although there was a dissent here, my guess is the U.S. Supreme Court will leave this one alone. Next, we turn to state law, a case involving veterinary malpractice. The plaintiff in Sharer v. San Luis Rey Equine Hospital filed a claim against the hospital for malpractice, which had led to the death of the plaintiff's horse. The horse died on February 2nd, 2008, and the complaint was filed on February 19th, 2009, 17 days after the apparent running of the one-year statute of limitations that applies to claims for veterinary malpractice under CCP Section 340C. It was true that in November of 2008, the plaintiff had sent to the defendant a pre-lawsuit notice of intent to sue, and counsel apparently believed that the notice would extend the running of the limitations period pursuant to CCP Section 364. Those of you who practice in this area know that Section 364 was enacted as part of MICRA, our malpractice reform statute. And it does extend for 90 days the limitations period for claims for a, quote, healthcare provider's professional negligence, close quote. Well, unfortunately for the plaintiff, and more so for plaintiff's counsel, while a veterinarian does qualify under the applicable definitions as a healthcare provider, the definition of professional negligence requires that the resulting injury be either personal injury or wrongful death. And as I'm sure everyone knows, an animal is considered property, and the damages recoverable for veterinary malpractice are property damages, not personal injury or wrongful death damages. Accordingly, Section 364 did not apply, and the plaintiff's claim was barred by Section 340's one-year limitations period. While counsel's mistake is understandable, this case does serve as a reminder that you really shouldn't take unnecessary risks when it comes to procedural rules and time periods. Counsel missed the one-year period by only 17 days. Was it really necessary and wise to rely upon an intent to sue letter when you could have been within the one-year period just by filing 3 weeks earlier? Maybe a lesson learned for counsel. Well, next, civil procedure question. It's a common technique used by meeting organizers to go ahead and begin a meeting exactly when it is scheduled for, even if one or more essential persons are late. The idea is that if you delay the start of the meeting, it only encourages everyone to assume that the announced start time is only advisory and not mandatory. But if you go ahead and start on time, you will discover that everyone will in the future make sure they come on time. Well, that is what the trial court did in Colony Bank Corp of Malibu versus Patel, where it began the afternoon session promptly at 1:30 as previously announced, even though neither the defendant nor defense counsel was present. Now, the plaintiff's counsel asked a witness only 7 questions before the defense counsel arrived. And defense counsel had the good sense not to object to the fact that proceedings had already begun, given that he was late. The underlying dispute here was a breach of commercial lease claim, which was tried to the court in a 4-day trial, so there wasn't even a jury. The court ultimately found against the defendant and entered a judgment in the amount of about $900,000. On appeal, the defendant argued, among other meritless points, that the trial court violated due process by beginning the afternoon session without defense counsel being present, and that this constitutes reversible error per se. Well, the 2nd District easily rejected the defendant's argument. Among other things, Section 594 of the Code of Civil Procedure authorizes a trial court to proceed with trial in the absence of a party, so long as proper notice has been given. As for due process, the defendant was given all the process he was due when the trial court gave the defendant notice that trial would resume promptly at 1:30. Due process does not require a tribunal in a civil matter to wait for a party to appear, particularly when no attempt at all was made to contact the court about counsel's tardiness. It's the party's responsibility to attend on time. Finally, we have a banking law foreclosure case. The plaintiff in De Brunner v. Deutsche Bank National Trust tried to avoid a non-judicial foreclosure sale of real property commenced by the holder of the deed of trust by arguing that such a foreclosure is forbidden unless the beneficiary has physical possession of the underlying promissory note. This argument was rejected by the Superior Court, which granted defendants demur to the complaint without leave to amend, and the 6th District agreed with the Superior Court. The plaintiff was essentially trying to get the courts to apply to real property foreclosures, which are governed by sections 2924 through 2924K of the Civil Code, the statutes and rules which are applicable to negotiable instruments under Article 3 of the Commercial Code. Unfortunately for the plaintiff, California courts, both state and federal, have repeatedly held that the foreclosure processes regulated by sections 2924 through 2924K are intended to be exclusive and exhaustive, thereby foreclosing, excuse the pun, any attempt to supplement those statutes by requirements found in the Commercial Code. And that's it for today's Kelso Report. Have a great day in the law.